But my understanding is that from the 5th edition to the current 7th edition, that the circumstances have been extended regarding how a termination would, what would be acceptable under the ethical guidelines for a termination to take place. Is that the case? And just finally, there was a huge amount of discussion here this morning in relation to fetal abnormalities. And the case was put by witnesses here this morning that under 43.3 of the Constitution, based on the Roach decision of the Supreme Court, that there is provision there within the current legal interpretation to make provision for that without an amendment to the Constitution. What's your view on that?
Thank you. Deputy Robert Dowds.
O'Hurley. Could I welcome our two expert witnesses? First of all, in relation to a remark that Judge McGuinness made, that the X-case judgment arose directly because of the 1983 referendum, and that it, in a sense, restricted the sort of judgment that could be made. What sort of judgment might have been made if that referendum hadn't been in place, or sorry, if the Constitution had changed that referendum brought about hadn't been in place? Could I ask you both if you would address the issue that I think Deputy Kelleher mentioned first, namely the extent to which legislation is required now to protect doctors in hospitals. I mean, the contribution of the medical people yesterday very strongly emphasised that they needed protection in terms of treating women, and also that they pointed out that you couldn't be absolutely sure in many cases whether a woman's life was actually in danger or not, but they would still have to make these decisions. And do you not think that we need to produce legislation to protect both them and the women and unborn children concerned?
Thank you.
And lastly, what would we do without our old enemy across the water, England?
Senator Van Tornow, yes, thank you.
Thank you very much. And I won't repeat questions. The two questions I have are in relation to actually the testimonies that we received yesterday from the medical professionals who very clearly asked us for legal clarity. And in fact, Dr. Fiona McAuliffe went further to say that without our proximity to the UK, that the questions we'd be facing here would be very different questions. So my first question is in relation to the threat to life, and we've had a considerable discussion on suicide ideation and intent. But whether we need to distinguish in legislation on a threat to life, whether it's physical or mental, do we really need to distinguish, you know, the threat to life and the expertise that needs to be brought in? So that would be a question that I would have for you, that surely the substantive weight should be given to clinical determination involving practitioners with relevant specialisms where appropriate. So it could be oncology, and others as well as the psychologists. And my second question is to elaborate on what Deputy Conway asked in relation to children, but also vulnerable adults. And I suppose what's occupying my mind at the moment is whether we need to do it via parallel legislation, whether it's through guidelines, and how do we deal with this question. And several of the legal people this morning, Justice McGuinness mentioned the Law Reform Commission report on consent, which I know you were president of the Commission at the time. So I'd very much welcome any guidance you could give us on dealing with the issue of consent, and particularly with regard to children, but also vulnerable adults.
Okay. I'll take the remaining members of the committee now so that we can allow for more time for the answers to questions, if that's okay. Okay, Deputy McGrath.
Look, I too want to welcome our two guests here this evening and thank them for their contributions. And just to ask, as a basic proposition, is it not the case that there is a separation of powers in our Constitution which does not allow the Supreme Court to direct the Oireachtas to legislate on any topic in a given manner? And thus that the Oireachtas can consider new medical evidence and current medical thinking and disagree with the X-case judgment. And the second question is, do you believe, this is to Justice McGuinness, do you believe that in a pregnancy that has become medically complicated, that there are two patients, considering the strong protection for the unborn child in Article 43.3 of the Constitution? Thank you.
Deputy Senator John Crone.
Gramagat. Again, I'm going to stand. I'm a little bit too tall to be heard when I speak into the microphone. I'm delighted to have the honour to share this chamber today with two such distinguished people whose very sincerely held beliefs I respect. And I have a few questions for Professor Binchy. In the first instance, Professor, I just would like to state that 5-minute walk that you referred to with respect to the National Maternity Hospital, as you know, and as others have pointed out, was taken yesterday in the other direction by people who came down here and told us what they wanted to do at the end of the 5-minute walk, and that was to legislate. And I'm glad that you're in agreement with them, because you also were suggesting, if I understand your opening statement correctly, that there is a need for legislation to clarify the issue with respect to life-saving abortions where the mother's life is in danger. And it appears to me from what you're saying that we should somehow specifically exclude suicidality from this. And again, I'm asking you as a lawyer to put this in the context of, and I'm sorry if I'm sounding like if we are collectively sounding like a broken record here, the Supreme Court judgment and 2 referenda. That's as high as it gets in civil authority, in civil society. That is the ultimate court of appeal. Now, unless I'm seriously misunderstanding you, sir, and I mean you no disrespect when I say that maybe I am, are you suggesting that we as legislators should ignore what has been said in our Constitution, confirmed in 2 referenda and interpreted by our Supreme Court? And if so, what authority are we in fact answering to? Who is the authority we should be answering to if it is not we the people, if it is not vox populi? It seems to me, sir, that what you are in fact suggesting is a constitutional coup.
Thank you.
I would also like, on one technical point, to ask that a portion of Professor Binchy's written submission is not suitable for inclusion in the official record. It refers to speculations about the cause of death of somebody whose death certificate has not yet been issued and whose inquest is still pending, and which should not, because it contains suggestions about possible causality, I believe, be in the record of this committee or of our Oireachtas. Thank you.
Thank you. Deputy Fitzpatrick.
Welcome the expert witnesses. The evidence I've heard in the last 2 days has confirmed that the mother and the unborn child are getting the best of care in Ireland. Doctors are doing their best to protect the mother and the unborn child, and that the mother and child are true patients. Also, I feel what was confirmed yesterday was that women who do have abortions do increase the risk of mental health, like depression and substance abuse disorder. Women who have abortions are more likely to commit suicide, and motherhood does protect against suicide. I'd just like to ask our 2 expert witnesses their opinions on these 3 matters. Thank you.
Thank you. Deputy Regina Doherty.
Gurv Magat, and thank you both for your very informative submissions. Can I ask, it was raised yesterday by the medics that in situations where there is an emergency situation, it's very easy for them to react knowing when there's a substantial risk to the life of a woman. But in situations where it isn't immediate, as in with maybe cancer patients or cardiac patients or other inflictions that mightn't be so immediate, it isn't clear, and some of the medics suggested yesterday that they are still sending women prior to those treatment, or those women are choosing to go. Can you give me advice from your perspective of how we legally could clear up that in legislation so that we can recognise what is substantial doesn't necessarily mean that it has to be immediate. It could be something that could be substantial to the life of the woman in 3 months and 6 months and 9 months, and how we could actually deal with that, please.
Thank you. And finally, Deputy Mary Mitchell O'Connell.
Much for your presentations. If I can just quote, I heard from one of the presentations or one of the answers, law has no values, it's a scaffolding. And can I ask you, given what the masters of the hospitals here said yesterday, do you think it is right that we would repeal the 1851 law? And then can I also ask you to specifically respond to advice to legislators that if we are pushing in legislation, and that's what we've said is going to happen, what exactly can you, Professor Binchy and Justice Catherine McGuinness, what exactly, can you tell me, what exactly should we be pushing into the legislation to curb the floodgates? Because for me and the constituents that are contacting me, that's what they're worried about. They are worried that this will open the floodgates. So I'd like to specifically know, what can we put in, rather than rubbishing and saying we shouldn't be doing it? Can we know what should we be doing? Thank you.
And we have 17 minutes left in the session, so 8.5 minutes each. Professor Pinch, you want to go first?
Okay, thank you, Chairman. There were a number of points there. I hope you'll forgive me if I allied a few of them. I think the first point is really this notion of doctors needing some degree of security from the legal situation in terms of what they do. Well, I think, the concern that doctors will be arrested and prosecuted and imprisoned, which was mentioned yesterday, is not actually a real concern, in the sense that the law operates in this area on the basis of a bona fide approach on the part of doctors. Bona fide approach. And any lawyer, I would say this in terms of non-campaigning lawyers, will tell anybody who's got a concern, any doctor who's got a concern, that there is absolutely no prospect that the bona fide judgment in terms of compliance with the existing law, which has already been stated in terms of life-threatening conditions, that would involve prosecution and imprisonment. That is an unreal concern. Could I also mention something which it might be of interest to us all, really, which is that we live with judgments which are made against a legal principle which is not actually incorporated in any legislation that I'm aware of. Very general principle, which is not on the criminal side, but on the civil side, and that is the law of negligence. We all must take reasonable care, driving a car, must take reasonable care minding children, and specifically, doctors must take reasonable care of their patients. Obviously, reasonable care of their patients during pregnancy, but also their patients in all situations. And that very general standard, which has no specificity other than those two words, take reasonable care, that standard is applied every day for every single medical decision that a doctor takes. If the doctor fails to exercise reasonable care, the doctor will be sued, a judgment will be made against the doctor, and if the doctor is working for a hospital, against the hospital in question. That level of lack of specificity, lack of legislation, lack of nailing everything down is part of medical practice throughout all disciplines, not just in the area of obstetrics, but all disciplines. And it is, incidentally, part of our life in terms of every decision that we take which involves care for other people. So I think, one can say in regard to law in this area, you can have a certain concern that you want everything nailed down, but actually we are living in a legal environment entirely outside the context of pregnancy, in which a generalized standard of taking reasonable care applies to doctors. And one can read on the internet, one can read all those judgments where doctors got it wrong, where doctors actually did not take reasonable care, and where a patient suffered or died as a result of that particular matter. That's point number one, which I would make. Point number two, just thinking specifically on the legislation point as opposed to some other approach. What we need here is clarity in the law rather than necessarily legislation. And it's funny, in debates how, not surprisingly perhaps, words become key words and they carry a lot of messages. And the word legislation has, at this stage, equalled ex-decision Supreme Court case. So, if you say we must have legislation, that means we must have legislation that incorporates the ex-decision. And that's a shorthand, as it were, for implementing the ex-decision. Well, actually, that is not necessarily the case. You could have a situation of clarification done, for example, by protocols, done by standards of practice, with the greatest of specificity. You could have bookloads of standards of clarification if you so desired. You could also have legislation clarifying existing medical practice in this particular area. So it's not a question of having a fetish about legislation, but rather a very well-based, reasonable concern that the word legislation is actually a shorthand for implementing the ex-decision. That's the crucial point that is to be made in that context. And it would be quite possible for this Oireachtas to introduce legislation if it so desired, or I would suggest other methods such as protocols and standards of practice in this area, which will cover the entire panoply of medical practice to treat a medical condition. You could do that over the next few months and produce some excellent material which would be useful and would allay any theoretical concerns that doctors might have. But I stress again, the evidence that you have received from doctors is that they are not actually holding back, failing to do treatments and administer treatments to mothers out of concern for law. They're actually going ahead and doing what they should do in the circumstances to save mothers' lives. So the actuality on the ground is fine.
Information. The doctor said that they encouraged people to go to outside the country for certain treatments.
Thank you.
But undoubtedly, when I make these statements, and I think it's fair to say this, that I'm talking about the general thrust of what the evidence that you heard. Absolutely. And I think that that particular position that you mentioned there would not represent by any means the majority view that you heard expressed yesterday. Senator Crown mentioned some points there in a fairly interesting kind of rhetorical way, that what we're talking about is a constitutional coup. I think he probably put some effort into thinking of that word, and I think it's I think with respect, Senator, it's not very fair word.
For the record, sorry, there's 30 seconds of effort.
Okay, thank you. Sorry, could we demur from engaging in insults, but also to clarify for Senator Crown, Professor Binchy's quotation was from the Irish Times article, which is covered in full in the presentation. It's from the Irish Times is where he's quoting in the article.
But it has been submitted. That certificate has not been issued in this case yet.
Okay, I accept that. But just to be fair to Professor Binchy, it's an Irish Times article he has referenced. Thank you. Thank
you very much, Chairman. If I could just forgive me, Senator, for concentrating upon you, and it's absolutely nothing personal, though I did sense a certain tinge in your presentation. I will say this, that you did make a point about, we've had 2 referenda already. How many more times do you want to hear what the people have said? That, with respect, is a serious, and I'm surprised, a serious reduction in the history of Irish constitutional referenda over the last 20 years. I and many others, in fact, as far as I remember...
Could you face the microphone? Sorry, because your nuggets of wisdom might be missed.
I'm sorry, sorry, Chairman. The substantial body of people who, to use that term, and I don't particularly like the term pro-life as opposed to pro-choice or any of these terms, I think the debate will not be won on the label, as you can appreciate. But those who would describe themselves as pro-life, many of them, indeed the majority, actually opposed the referendum which proposed the kind of change that you mentioned in 1992. When we come to 2002, a certain segment of that pro-life constituency also opposed the referendum in question. That's an important point. If we're going to give a nuanced history here, it would be an injustice not to mention those facts. Also, I'd point out to you, we're talking about a referendum of 20 years ago and a referendum of 10 years ago. We're talking now about a situation which has been precipitated by the European decision, which asks for clarification in the law. To ask for clarification in the law, it does not ask us, and I say this again, it does not ask or insist that Ireland is to implement the X decision. That is an absolutely crucial point. Senator Burke asked the question, did the judge get it wrong? Am I saying that the judge in his introduction in the expert group said something that was not true? What I'm saying is something different, which is that the judge in his statement that you read out there gave the truth, but it was a partial truth, because he quoted some of the decision and invited the reader to join. I think it's a fair commentary to say that the reader certainly would be likely to draw the conclusion, therefore we must implement the X decision. I think that is the manner in which that quotation was used. If that is the effect of reading that particular text, that is a mistaken effect, and I'm simply pointing out the mistaken effect in question. Finally, the point was made about principle. I made the argument, and I stand over the argument, that if we change our practice in Irish hospitals, whereby obstetricians are carrying out abortions on women who have no physical illness whatsoever, on unborn children who have no physical difficulty themselves whatsoever, on the basis of the ground of suicidal ideation, we very definitely will have changed the principles on which medical practice operate in this country. And that shift in principle may not happen overnight. But if in those circumstances it is possible to take an innocent unborn child's life, in those circumstances, as Senator beside me, I should say, Judge McGuinness mentioned, I think it's fair to say, and I hope I'm not misrepresenting you, Judge, that you did say that you felt that this is a summary of your summary, that the X decision, as it were, was packing in certain other grounds under the life ground because it was the only ground that was available in the circumstances. And I hope I'm not doing you an injustice in saying that. But already we see, if we can do it in one particular context, why not do it in other contexts? And we're dealing with an area of tragic human conditions. We're dealing with situations where any person of a humane disposition feels tremendously for the circumstances of the pregnant woman. And if you feel tremendously for the circumstances of the pregnant woman in one case, and you can say, we can take the innocent life in circumstances where there are no medical conditions that impact in that case. In those circumstances, the principles have been changed, I would respectfully say, and the culture will have been changed for the future.
Thank you.
Thank you.
Mr. Justice McGuinness.
Thank you. There's been quite a number of questions here, and I'll try to deal as quickly as I can with as many as I can. First of all, with regard to the Medical Council, I simply don't know whether they extended their circumstances, and that I'm not expert to answer that question. With regard to the question about the X case arising from the 1983 referendum and what would the judgment have been if we hadn't put in the Article 40.3.3. Well, obviously I don't know, but I don't think it may not have been all that different, really. But I obviously can't answer that question. On the other hand, I do think it's important to answer that the question about the protection of doctors, and I think, and the question raised by Deputy Mary Mitchell O'Connor about repealing the 1861 law. Yes, I do think we should repeal the 1861 law. I think there has to be protection of some kind that would, for instance, deal with the question of someone who is running an abortion factory, as it were, an illegal abortion factory. You would need some area of the criminal law to deal with that, but we don't need that to be framed in 1861, and we don't need to necessarily have the level of penalties that we have. And I do think that doctors are worried about that. Okay, I'm sure they probably know that the Director of Public Prosecutions is not out there watching every doctor, waiting to prosecute them, but it's there in the back of their minds. And I think that possibly the kind of negligence regime that Professor Binchy is talking about, and which already exists in civil cases, is a reasonable approach, and I would go along with that to a large extent, but at the same time maintaining some level of criminal sanction for someone who was deliberately engineering illegal abortions. I think you do need that as well. And of course, that perhaps is what we might have to a much greater extent if we didn't have, as one of the deputies said, the old enemy there beside us. With regard to Senator Van Turnhout about the proximity of the threat well, she mentioned the proximity to the United Kingdom. With regard to the threat to life, I don't need that. I think perhaps you're right that we don't necessarily need to specify that it is a threat to life. And it is interesting that in his judgment that the Chief Justice in the case he specifically said that he felt that amongst the matters to be so regarded, the court must concern itself with the position of the mother within a family group, with persons on whom she is defended, and with persons who are dependent upon her and her interaction with other citizens and members of society. Having regard to that conclusion, I am satisfied that the test proposed on behalf of the Attorney General, that the life of the unborn could only be terminated if it were established that an inevitable or immediate risk to the life of the mother existed, for the avoidance of which a termination of the pregnancy was necessary, insufficiently vindicates the mother's right to life. Now, that's a general statement. It's not about suicide, and I think it meets one of the questions that were raised here about the cancer question and the serious illness question, that it has to be an immediate right to life, insufficiently vindicates the mother's right to life. I mean, quite a lot of these questions are in fact discussed in the judgment, discredited and all as it may be. With Deputy McGrath talking about the separation of powers, yes, of course we have the separation of powers, and the judiciary doesn't direct the Oireachtas to enact as to what legislation they are to enact. Of course they don't, but they can point out that legislation is needed in a certain area, particularly, and this doesn't just apply to the abortion area, it applies to lots of other areas as well, where the courts have said, you know, we need clarity of legislation in this area because we are being asked to decide, and we are therefore doing the job that should be done by the Oireachtas, that under the separation of powers, this should be the Oireachtas' job, not the judiciary's job to make this decision. And that's precisely why Mr. Justice McCarthy, even in 1992, said that the failure to legislate in 8 years was inexcusable. As regards the need for clarity and who are we answering to, well, I think I've really more or less dealt with the question of the different referenda, but I would say that if we're going to have any more referenda, that we should put before the public various different options to answer, rather than simply saying, do we want X or Y and I think that's important. There are other views that could be reflected in the public's, in the way the public vote. With regard to, yes, I think the floodgates question, well, the way things are at the moment in regard to that question raised by Deputy Mary Mitchell O'Connor, I think that's in your own hands. That obviously, it doesn't look to me that the very limited kind of legislation that you would be bringing in, if you follow the ex-judgment, that very limited legislation could possibly open any floodgates. But if you're worried about the suicide ground moving in that direction, well, then it is for the Oireachtas and under both the outline legislation and regulations thereunder to set up a strong gateway, as it were, a difficult gateway to that, which would need convincing medical evidence. I think that's really up to you. Protocols and standards are all very fine, but when it comes to, when crunch comes to in front of the courts, a protocol and standard is not enough if the law is needed. And you see, Professor Binchy speaks of everyone feeling for the circumstances of the pregnant woman. Of course we all feel for the circumstances of the pregnant woman, but we also need to do something about it as well. So that I do think that, I think that's by and large covered the
We have 10 minutes,
questions.
until 7 minutes past 4, and there's a number of speakers who indicated: Deputy Kelleher, O'Quayle, Nocton and Burke. And if you could be a minute each, please, to allow for replies from the witnesses.
Just very briefly, primarily to Professor Binchy, yesterday the medical professionals and obstetricians did say that they have at times had to refer women to England for termination so that they could continue with life-saving treatment when they returned, and they were quite clear on that. And the reason they were referred was they were unsure because there wasn't an immediate risk to the life of the mother, but that there was in all probability a risk to the life of the mother at some stage in the future. So I just want to get a bit of clarity on that particular issue. Also, Professor Binchy, you did say that we could clarify the grounds on when a termination could take place without legislation, possibly protocols or other guidelines. But equally in the context of suicide itself, are you saying clearly, Professor Binchy, that we can actually ignore two referenda, an ex-case interpretation, or the ex-case interpretation, as a legislator, and just legislate on medical grounds and legislate to exclude suicide? Or would we require a referendum?
Thank you. Deputy O'Quayle, 1 minute, please.
Yes, well, very quickly, I asked these questions already of Professor Binchy. I thank Justice McGuinness for her replies. But Professor Binchy, I had asked you because you suggest that, as in most other countries which have changed their laws on abortions, that further extensions follow. I made the point to you, I asked you, surely the Irish people would be the bulwark in relation to that, because nothing is proposed to change in the Constitution whatsoever, and no change can occur unless the Irish people give their express consent. And lastly, the suggestion that we're going to see a very different situation, a deterioration in the acknowledged high standards within our maternity units. I have to say that no evidence has come before these hearings that would suggest that those who we trust with the responsibility of oversight and direct provision of services to pregnant women, there is nothing to suggest that we cannot look forward to that continuing in all circumstances.
Thank you. I missed Deputy Catherine Byrne in the beginning, so my apologies for that.
No, I'll just be very brief. I just want to say to Judge McGuinness, you started off by making a statement saying that you didn't know why you were invited here. Well, I think it's clear to all of us sitting here why you were invited. You're invited because of your honesty and your wisdom. And I think that's just about this hearing is about. It's about us listening to the honesty and the wisdom of everybody who's spoken here over the last 2 days and tomorrow as well. And I think you hit the nail on the head when you said it's not us sitting in this chamber. It's the people who are looking on. And not the people who are the legal minds or the medical minds. They're the women of children out there who have the difficulty when their child arrives and tells them they've been abused or they've been raped, and where do they go from here? So I think you've hit the nail on the head. William, you spoke about human rights, and I'm a mother and I believe in human rights, but I believe in the fact when somebody comes to my office and says they have a difficulty because their child is now pregnant, and what do they do with them? And I believe those children have human rights as well. And I didn't see that answered in anything that you said.
Thank you, Deputy. Senator Burke, you indicated you've been already because time is slipping on. If you can be 1 minute.
Just very briefly, and it's in relation to the issue in relation to doctors and looking for clarity. Can I just say from my own contact with doctors in hospitals right around the country, they are looking for that clarity because they feel at the moment that they're actually walking on eggshells in relation to the decisions they're taking. They're not only afraid of criminal prosecution, but also afraid of being reported to medical council for someone's view might be that they're stepping out of line. And that's the reason why they're looking for clarity. And I think it's important that that clarity is given.
Thank you. Deputy Naughton, if you could be 60 seconds.
Very briefly, if I could ask Professor Benchy in relation to two questions I asked earlier regarding fetal abnormalities and the regulatory creep within the Medical Council ethical guidelines.
Thank you. Okay, we have 6 minutes, so if Ms. Benchy, if you want to take 3, and Mr. McGuinness, Ms. McGuinness 3 as well, please.
Okay, hope I'm going to cover all those points. If I might just take the last point there about the fatal abnormalities, I think the view was expressed this morning that the law that exists in Ireland will be interpreted as providing for abortion in those circumstances. The short answer I would give is that I do not agree that that is how the law would be interpreted. Nothing is certain in this world, but that is my view. I take the point about the D case, but my view is that that was a very speculative argument made, which succeeded in that case, but that the law would not be so interpreted in Ireland. Picking up on what Mr. O'Quailon said a second time, and it's a fair point. I thought I'd answered the first time, but perhaps I hadn't answered it clearly enough, which is, well, aren't we locked into the X decision here, and therefore there's no problem in terms of a rolling development of the law into further areas? Well, I think the answer I gave before, and which I would give again, is that the change of culture involved in transforming Irish medical practice so as to allow for the provision actually of abortion, the actuality of abortion and the actuality of no due requirement of due care towards the child, the requirement also that suicidal ideation would be a ground for abortion, that cultural change would have an effect. As I say, let's not exaggerate these things. Not tomorrow, not the next day, but over a period of time would have an effect on medical practice in this area, such that the attitude towards abortion will be transformed. The net effect of that is that the actual interpretations of the grounds, I think it is reasonable to project, I should say, would change over time. We have experience, not just in England, though the experience in England is striking on this particular point, but in many, many countries, that when a change in the law was made for the best of reasons to allow for the intentional destruction of the life of the unborn child, once that cultural change is made, it's very, very difficult to stop. And we heard of the tragic case that you mentioned there about a young girl who might have been raped or subject to sexual abuse. Should we not have an abortion in those circumstances? I believe that you were saying that it would be appropriate to do so. Already we would be discussing these matters and the extensions in these hard cases. It would be very difficult to have a principled basis for opposing them. That is the point I'm making about the cultural change in this area. So essentially what I would say is it is a human rights question. Sometimes human rights are difficult. Sometimes the actual experience of protecting human rights is difficult. And the final point I would make in this area, linked into that very difficulty, is that as legislators and as society, if we are going to say that unborn children are to be protected making absolutely sure that the lives of mothers during pregnancy are equally protected and making absolutely sure that no mother dies. But if we are to say that unborn children, their lives are to be protected, there is a very solemn and real and tangible economic and social obligation on our society to provide the support for women who find themselves in crisis pregnancies. Not just lip service, but actual social and economic support. That's a practical question, but not a question perhaps to be addressed in detail today. But when we're talking about changes in the law, that is an area where the law can introduce, and legislators can and should, I would suggest to you, introduce changes to provide the social and economic support for women who do find pregnancy a challenge. But let us not, on the human rights issue, let us not change our culture whereby we do recognise that to be a human being at all stages, from the very beginning to the very end of life, is to be part of an important, crucial, valuable enterprise, the human experience of life. Our culture is built on the notion that every person has equal dignity and entitlement to equal respect, equal rights. Let us not, at this juncture, throw away that very important principle for the best of reasons and the best of motivations. Let us not throw away that principle, but rather do what I mentioned in my very first remarks to you. Look down the road 500 yards and see what they're doing there in those hospitals and give legal protection to that. Don't change the law so as to bring in an abortion regime. Thank you, Chairman.
Mr. Justice McGuinness.
Well, I would like to thank Deputy Catherine Byrne very much indeed for her very kind remarks, and I do appreciate her understanding feeling for the women in her constituency, which I know she has felt for many years. Just with regard to the question of fetal abnormality, I perhaps would not be quite as certain as Professor Binchy, but I certainly would not be certain that a doctor would be protected in the case of fetal abnormality. I don't think fetal abnormality would come under the X case, really, and I don't think that, I think that it's highly doubtful that a doctor would be protected in such a situation. So I think that doctors do need to have that clarified at least. And when I talk about fetal abnormality, I think what doctors are looking at is extreme abnormality where the child is incapable of being born alive, rather than they're not looking to say, I mean, doctors are not asking to be allowed to abort children who perhaps are suffering from Down syndrome or something like that. It's not about that. It's about the time when the child is already destined to death in the womb, and that is dealt with. I think it's highly doubtful what the law would be. Professor Binchy has said that if we're going to do this, we're going to have no requirement for due care for the child. I don't believe that legislators are going to bring in laws that would approach it in an uncaring manner like that. I think that you have the opportunity if you are approaching it as you suggest you're going to, by having an outline law and regulations, that you have the opportunity to, and which you should do, is to look at the questions of due care for the child as balanced as is required against the life of the mother, and that can be dealt with in the regulations. And in the end, when we look at the values of Irish society and whether we're going to change them, I think that you understand that what I'm saying is that our values are considerably more subtle than you might think when you look at overall what we really do about life, as opposed to what is a sort of ideal which we can set before us, and then when we come up to the human dilemma, what do we really do about it? And I would say that I really do plead with you not to be too affected by a kind of bullying approach, or from either side of the question, from either the ultra-liberal who are looking for you to introduce abortion on demand, or from the extreme, as what describes themselves as pro-life, who are trying to get you to narrow the law and think about where the middle ground is and what the majority of your constituents may feel.
Okay, thank you. We now have the session of 20-minute duration for non-members of the committee. There are 11 non-members of the committee who have indicated to speak and to ask a question. It will not be possible to get all 11 in 20 minutes. So I would ask people to be brief and ask a question rather than making a speech. So Deputy Flanagan.
Thanks, Chairman. Yeah, I'll be very brief. Just to thank both expert witnesses for coming in. Can I ask you both, should a court evolve in relation to its judgment in light of developing scientific knowledge, even if that is the Supreme Court? We know that the X case happened 20 years ago, that there has been extensive evidence from psychiatrists, and the evidence is consistent with the view that abortion may be associated with an increase in the risk of mental disorder. And that if that is the case, and abortion is not a treatment for suicide, as we heard yesterday, why should the Oireachtas then make law that ignores that reality? Can I ask Justice McGuinness regarding the X case, which has no time limits, do you think that the government should legislate for direct abortion where the woman's life is at a real and a substantial risk, including the case of suicide up to birth? If not at birth, at what point would you consider that it is acceptable? And do you believe in circumstances where psychiatric judgment shows a threat to the life of the mother, that someone should be appointed to appeal and speak out on behalf of the unborn child?
Thank you, Deputy. Deputy Timmins, if you can be brief as well, please. Thank you.
Thanks, Chairman. I'd like to thank Professor Binchy and Justice McGuinness. And ask them, would they agree that, the difficulties particularly in the area of suicide, have paralysed any positive development over the last 20 or 30 years. And would agree that maybe there's merit in view of the contribution from the Civil Liberties this morning, where their representative stated that irrespective of what proposal comes forward, it may end up in the Supreme Court. So based on your experience of the issue over the last 20 years, is there merit in splitting the decision? Let's go with the positive, where there's almost unanimous agreement on repeal the 1861 Act and replace, bring in legislation for medical procedures on the physical guidelines and deal with that. And then let's look at the suicide issue and any other related issues separate, whether it needs a constitutional referendum, whether, as the government has decided already actually to bring forward legislation on it, but that we can get the medical procedures passed. Hopefully there wouldn't be challenged with the Supreme Court, repeal that 1861 Act again, and then to deal with the other issue, which almost certainly will end up with the Supreme Court, but will give protection to the likes of the Master from Hollow Street and yesterday in the medical profession, who do look for protection in their practice. I'd just like to get your view on that, please.
Thank you, Deputy. Senator Philema Healy-Ames, if you can be brief, please.
Chairman, and again to the two witnesses, thank you so much for your wisdom indeed. Professor Binchy, it's clear from what you're saying that in response to the ECHR judgment that you believe Irish law can be clarified without legislation. And this is a follow-up comment, I suppose, to Deputy Timmins. If so, how would we make this an adequately safe context for medics to practice in and pregnant women in difficulty, bearing in mind that the medics made it very clear to us here yesterday the real concerns about their lack of legal clarity. And bearing in mind in particular Professor McAuliffe's admission here yesterday that we send cases to the UK, cases with medical complications, so we can save the life of a woman because it's unsafe for them to do those procedures here. And by the way, Professor McAuliffe is a member of the executive of the obstetrics and gynecologists in Ireland, so she's not representative. And Justice McGuinness, just one question for you. In A, B and C, the applicant C did not argue suicidal ideation, and therefore her legal position is different to that of the woman in X. The ECHR made no reference to legislation. Why, therefore, do you think we do need to legislate on the basis of X arising out of the A, B and C decision?
Thank you, Senator. Senator Paul Bradford.
Thanks very much, Chairman. Two very brief questions and welcome to both witnesses. Professor Binchy, you might please try to expand insofar as possible on your view that somehow the range of options being presented by the expert group is somehow not as inclusive or as full or as broad spectrum as it could be. And Justice McGuinness, firstly, welcome back to your previous House of Employment. You're very welcome indeed. You mentioned on two occasions that lovely phrase, the human dilemma, and I think it's very difficult for any of us to be dismissive of that issue of the human dilemma. But would you agree that, in our attempt to genuinely respond to the human dilemma, we also have to be cognizant cognizant of the fact that, particularly I suppose in countries where we have a lot of knowledge of Britain and the United States, where there was a genuine response, an attempted genuine response to the human dilemma of abortion in the late 60s, early 70s, that it went horrifically wrong. And does it not teach us a lesson that we must proceed with extreme caution and extreme care in responding to what you rightly call the human dilemma, but sometimes the initial response to that human dilemma can result in, an answer that is neither humane or a solution.
Thank you. Senator Walsh. I take all the speakers first, and then I'll go back to the panel, to be fair to members who've been here for the afternoon and for the morning. I'll take all the speakers first, then we'll go back to
Thank you, Chairman. Can I just compliment both contributors indeed for their honesty, I think, in their submissions, and I think the session is enhanced by the fact that you have different perspectives, which we didn't have this morning. And it brings me to a question which was put to us this morning. The notion was canvassed that we could actually legislate for fetal abnormalities, which is a very difficult situation, I must certainly concede, and one that most of us have a great deal of sympathy with, without actually going for a referendum. That's number one. Secondly, mention was made of a failure to legislate. In fact, it was a decision made by successive governments not to legislate, for the very good reason that suicide was, in fact, very problematic from the point of view of how it might be exploited. In relation to the X case, but as a general principle, can I ask each of you, given the separation of powers between the judiciary and the Oireachtas, is the Oireachtas obliged to legislate in respect of specific Supreme Court decisions? Or could we, in fact... Sorry, I didn't realise that. Yeah. Or could we leave it to case law? And I'm canvassing that because I think Deputy Timmins has put his finger on it. I don't think there'll be a great deal of difficulty in members and the general public subscribing to dealing with the real medical issues. But suicide is definitely going to be a major controversial issue because of the experience in other countries where it's actually ended up opening the floodgates, and as Anthony Clare said many years ago, is used as a wedge in many restrictive areas, in fact, to put in abortion. And finally, can I just ask, should the laws we enact be just? Is there an obligation on us as legislators to be just? I ask it purely in the context that we now know from the evidence we got that suicide cannot be predicted with any great degree of accuracy, and therefore, given the right to life, equal right to life in our Constitution, if we go that route, we know that that law will create an injustice for many vulnerable, unborn children.
Deputy Eanna Reardon.
Thanks, Chairman.
If member could be brief, please, to be fair to other colleagues as well.
I want to thank both speakers. I'm an admirer of Catherine McGuinness for a long time, and I particularly admire Professor Binchy's stance in the 2004 citizenship referendum. Can I just ask both speakers to give a comment on the Article 34.6, which says the decision of the Supreme Court shall be, in all cases, be final and conclusive? How that will have a bearing of how we operate things here in terms of legal certainty. Isn't it the fact that abortion is law in this country, and that the abortion is law including the risk to life of the mother in terms of mental health and suicide? And can I also just ask you to expand on what has already been asked, but I just want to, if you have a chance to expand on it, because it was part of a submission, a draft bill given to us by a previous speaker this morning, Dr. Simon Mills, in relation to lethal fetal abnormality, because his contention was that a fetus without any prospect of life was not protected under the Constitution. And just to give your interpretation on that. Thanks.
Thank you. Senator Mooney.
I'll to re-echo all of the compliments that have been paid justifiably to both of our witnesses, and to thank them for the clarity that they brought to the questions. Two specific questions. One to Honourable Justice McGuinness. It's not unconstitutional for the Supreme Court to revisit decisions that it has taken. In fact, it happens not quite frequently, but it does happen. Could you perhaps outline under what circumstances could or would the Supreme Court revisit the X case in light of what you have heard already about the developments in the whole area of psychiatry and psychology? And to Professor Binchy, who is a proponent of a referendum, can you outline at this remove and in the absence of any specific legislation coming from government as to what the question would be that would be put to the people in the context of the fact that you've already heard that there have been two questions asked of a similar nature over a 10-year period. And by the way, I have no difficulty about recurring referenda. It happens regularly and in countries that have referenda. But could I add the brief question, is it that the government, one assumes, will propose legislation. Should the vote be on the legislation that has been proposed by the government, or should it be something separate or different? In other words, what would be the question that would be put to the people?
Thank you, Senator. Senator Katrin-Savoni.
And again, thanks to the esteemed lawyers. It's a great exchange and a necessary exchange with us as lawmakers. So 2 quick questions, if you could answer as lawyers. First of all, do we have an obligation to implement the recommendations and judgments of the European Court of Human Rights as outlined in Article 46 of the European Convention? And secondly, what was the judgment itself? And I think Professor Binchy has put forward that at least initially you spoke about that the judgment itself was that we actually haven't legislated for Article 40.3.3. But as my reading of the judgment is that, and I'm going to ask maybe Justice McGuinness, is that we have not legislated for Article 40.3.3 as interpreted by the Supreme Court in the judgment. And that and a corollary question to that is that we have not legislated for the judgment, as distinct from, I think, Professor Binchy, you've been arguing that, in fact, the judgment was looking for clarification as distinct from legislative implementation. And I just refer to paragraph 254 and paragraph 264 in the actual judgment of the European Court, where it speaks about a lack of legislative implementation a couple of times.
Thank you. Deputy Durkin. Very briefly now.
Thank you, Chairman. My apologies for not being present all of the time, but I was watching and listening. Can I ask, in respect of, and I compliment our legal experts for the clarity with which they've addressed the issues. Can I ask, what is the legal position where a practice becomes established over a period of time in the absence of legislation, but is still practiced, either administratively or in the courts, in this particular context in medicine? What is the situation in the event of there being a legal challenge? Is the lack of legislation a weakness in the case, or the existence of legislation a strength in the case? And this apropos the question raised by doctors.
Deputy Tobin.
Yeah, I just want to say I too am honoured to have witnessed this fascinating exchange here today. And I asked this question to get a genuine insight from yourselves. With regards to the Supreme Court decision, it stated that there had to be a real and substantial threat to the mother's life. Is there any quantification of that real and substantial threat? For example, we heard evidence yesterday which said that out of 100 predicted suicides, typically 3 occurred. And would that level of prediction equate to a real and substantial threat in that case in the future? And the second point would be that Professor Binchy mentioned that there were gaps maybe in the Supreme Court judgment. Would that make it more likely that in the future, if this issue came before the Supreme Court again, that whatever legislation which is proceeded with might actually be deemed unconstitutional in the future? And why was that gap there? Was it the case that the Attorney General didn't provide or didn't request the necessary psychiatric evidence at the time?
Thank you. And finally, Deputy Creed.
Thank you very much. Cahill, just 2 brief questions, and I'd like to compliment both our witnesses for thoughtful presentations. Professor Binchy has repeatedly referred to the 500-yard walk or the 5-minute walk in respect of current medical practice, which is informed by the Medical Council guidelines. As I understand those guidelines, there is a clear and bold reference to therein suicide being grounds for a termination as a result of the X case. Could I ask him if he is implicitly suggesting, therefore, that the status quo which is contained, which is informed by those guidelines, should be left to operate without any direction from the legislator as to how medical practitioners should interpret that specific bold provision in the Medical Council guidelines that suicide is a grounds for termination? Could I also ask, and this is my final point, if our 2 eminent guests might give us the benefit of their reflections on the recently released state papers under the 30-year rule, particularly on the successive AG advice to the governments of the early 1980s in respect of the referendum, which inserted 43.3 into our constitution, and the predictions which came to pass as to what the consequences of that referendum might be.
Thank you. Okay, Professor Binchy, Dr. Ms. McGuinness, I know we've had a lot of questions on it. I apologise for the avalanche, but I think it's important to hear all the members who've been here for the afternoon, indeed for this morning as well. So you might start, please.
Okay, thank you, Chairman. It's been a long session, and I think I'm going to be brief, if that's okay. Just pick up the last point first. When I read about the papers 30 years ago in the Irish Times on the 1st or 2nd of January, I made a resolution. I must read those papers because they sound fascinating, because they seemed to say, if I'm reading them correctly, that Mr. Sutherland, not responding to the Fianna Fáil proposal, because his response to the Fianna Fáil proposal in early 1983 is in the public domain, but rather Mr. Sutherland, before the wording ever came out from Fianna Fáil, appeared, if I'm reading the papers correctly, to be opposed to the whole idea of a constitutional referendum on a basis of a number of points. The reasons why he gave against the very idea of a constitutional referendum bore a striking resemblance to his critique of what emerged from under the Fianna Fáil wording in 1983. But it's a novelty to me, and certainly as far as I remember, not one word was said in 1981 or 1982 that Mr. Sutherland was opposed in principle to the very idea of a referendum. I hope my memory is not fallible on that. That's why I'm going to read the material when the dust settles down a little bit on the Oireachtas hearings here.
Go back to the modern age, no, it might be.
Okay, let's go to the modern age. Let's go to the future, if that's okay. I think the number of contributors there raised the points about must we, can we? Are we bound by, the constitutional provision which says that a Supreme Court judgment is final? Senator Sapone said, the European Court, in the various paragraphs you mentioned, said, implement in accordance with the existing constitutional provisions. Forgive me, but I think I have dealt with these points before, and I will say them again, if I may. The Supreme Court judgment, just like any other Supreme Court judgment, is of course the law of the land. There isn't any dispute about that. We're not challenging the legitimacy of the decision at a fundamental constitutional level. There are no constitutional coups, to use the expression of Senator Crown. But that does not deprive us as a part of the democratic process from critiquing a decision. I remember there was a decision, if I may go to history again for a moment, but I think it is enlightening, where the Supreme Court interpreted the Adoption Act in a particular way. This is about 35 years ago. We had a referendum. Everything was fine thereafter. It's absolutely reasonable for the democracy to respond to a Supreme Court decision. So I beg you, do not proceed on the basis that you have to implement the Supreme Court decision. You emphatically do not. Nor with respect to Senator Sapone, who has read the judgment from the European Court, does the European Court of Human Rights require us to implement the X decision. On the contrary, it does require clarity in our law. It specifically says that it's up to states to develop their law in this particular area. There is no right under the Convention to abortion, and we are perfectly free in this area to bring in, as I say, a legal system. Again, going back to what I mentioned again and again, the existing practice in medical hospitals. Our side of the argument is emphatically empirical, emphatically on the basis of what is happening already in Irish hospitals. Those who are proposing that the law be changed are proposing a change of culture in this area. The change of culture will involve the intentional taking of the life, the termination of a life of an innocent human being. That is a radical change in Irish society. Since independence, no such proposal has come before the Oireachtas, nor indeed, before the wider community, that there should be such a proposal. I strongly say, and I repeat, what we are looking for here is something emphatically simple to provide. Existing medical practice should be given legal support. No change to change the situation and to change the culture in this country. Thank you.
Thank you. And Mrs. McGuinness.
Thank you. There have been a great many questions asked here, some of which are relevant to what I can say, and some of which I simply can't answer. Looking at the evolvement of Supreme Court judgments, which I think a number of people were asking about, the Supreme Court doesn't just, and no court just suddenly starts issuing statements about this and that. Courts deal with cases that come before them, so that you would need a further case to come before the court if you are going to ask it to change its point of view. It does sometimes, very occasionally, happen that the Supreme Court changes its approach it doesn't do it. It follows a rule known as stare decisis, which means what is decided stays decided in the vast majority of cases, because it would involve introducing a huge uncertainty into the law if it was to change daily from time to time. And I think even Professor Binchy would accept that. So that you can't really expect the whole thing to change ever so conveniently, the way it might make it easier for legislators, for the Supreme Court to suddenly up and say, well, we know that this is creating a problem, so we should issue a